Hello everyone. I put out the video with Blake Lively. She actually responded to this order from Judge Lyman. And I put out a video going through her response. For Judge Lyman, basically, he wanted the parties to file something to say why final judgment should not be entered, why the New York Times motion should not be dismissed as moot. New York Times, if you remember, on the 12th of September, they filed a request for the judge to enter final judgment on the case that was dismissed back on the 9th of June. And the overwhelming number of questions I've had have been on two things. One, why didn't Wayfarer file anything? And the short answer is there's no argument here. The New York Times was dismissed with prejudice, so they can't bring that back. They can file a motion for reconsideration based on new evidence available. So that's the way they could. That's why they could bring it back. But obviously, because it was with prejudice, they couldn't just amend a complaint. So that's that answer. So there's nothing to answer really, nothing to argue against. I believe it's more likely that they wanted the final judgment entered into, so the 30 days time limit to appeal starts. So, and then that leads nicely into the second most common question I got was, do I think Wayfarer might appeal this and why? And the first part of that question is a simple yes, I think they could actually. It's not definite, but I do think there's a strong possibility. So why do I think there's a chance they could appeal this? Well, a couple of things. Firstly, Wayfarer's arguments were strong. So the New York Times in its article said that they relied on a CRD, but they also said there were thousands of pages of documents. The CRD is not thousands of pages. It just feels like it. But the thousands of pages of documents, which they also say was obtained by a legal subpoena or a subpoena. I don't know how I can't remember how they exactly worded it, but they stated was obtained by subpoena. Well, the first problem is that subpoena, the only subpoena that's ever been used to obtain those documents, so at least at that point, was the Van Zandt one. And I would have thought the New York Times would have done its due diligence. And if it had seen Van Zandt Inc., against those 1 to 10, then they would have been asking some questions. And I do think they did. I think they did ask questions. I personally think that there was collusion going on. The metadata shows at least the 31st of October. I think the metadata is going to come back and it's going to be an important point of the appeal. Because if Wayfarer can nail down that date and conclusively prove the New York Times was already working on this article 2 months before Blake Lively even filed her CRD, then I think that could destroy litigation privilege. And the reason I think that is if we go to here, this is a June 9th order on the motion to dismiss. This is Judge Lyman. So let me just see. Yes, so here, the rationale of providing a bridge between protected statements supports application of the privilege here. the litigation privilege can protect statements in a complaint that has not yet been filed if they are related to an imminent lawsuit or judicial proceeding which is actually contemplated seriously and in good faith. Thus, if the CRD complaint had been sent between the lively parties, or to an adversary as an attempt to secure settlement in good faith before the complaint was filed, the statements would be regarded in the course of the proceeding and the litigation privilege would apply. So, Wayfarer's argument was that the CRD was it was a draft. It wasn't it wasn't completed. Like the I can't remember the exact wording, but they argued that it didn't qualify for litigation privilege, and I think Lively thought that too. She obviously had the benefit, the good fortune for her, that Stephanie Jones was, by the sounds of it, still accessing Jennifer Abel's iCloud. And I've always thought from the day it actually happened that the likelihood of Blake Lively filing a lawsuit in New York against Wayfarer and Jen Abel and Melissa Nathan and Jed Wallace on the exact same day that the Wayfarer parties, including Jed Wallace, filed a lawsuit against the New York Times was a complete. Well, I don't believe in coincidences. And now we know that Stephanie Jones was accessing Jen Abel's iCloud, her communications, up until January this year, after the lawsuits were filed. I feel it's a fairly safe bet that Blake Lively would have had a heads up that that lawsuit was going to be filed and got one in on the same day. Because if we read this here, assuming the lawsuit is actually filed, the statements will also be privileged when published by the media outlet. Applying the fair report privilege in this situation protects the bridge between these two privileges, avoiding the result in Shavar that an intermediary could be held liable for defamation for passing along statements that are privileged on each end. As so long as litigation was actually contemplated seriously and in good faith, the fair report privilege applies to a party who communicates a complaint to the press before that complaint is publicly filed. And then Lyman goes on to say, here, there is no basis to infer anything other than litigation was actually contemplated seriously and in good faith. In the first place, Lively commenced litigation. She filed a CRD complaint within months of the events described in the CRD complaint, and not long after it was plausibly given to the Times. Now, if we can prove, just to pause there, if we can prove that actually the New York Times already had the information before the CRD, that makes a difference. As Judge Lyman is working on the fact that, well, they were given the CRD complaint, upon it being filed, and in record time, we're able to bang out a 4,000 word, article. He goes on to say, 11 days after she filed the CRD complaint, Lively filed suit in this court, making the same allegations that she made before the CRD. So, yes, I'm just looking to see if there's anything. Yes, so and then he goes on, right? I will read a bit on, actually. The Wayfarer, so this is the Wayfarer parties. The Wayfarer parties assert that the fact that Lively eschewed the administrative process and filed suit in federal court instead demonstrates that she did not file her claim in good faith. But the conclusion does not follow the premise. It is a requirement under California law that before suing for any violation of California Fair Employment and Housing, a plaintiff must file a timely and sufficient administrative complaint with the CRD. The CRD then issues a right to sue notice allowing the plaintiff to proceed to court. The court, but not the agency, is authorized to award either punitive or general compensatory damages. Thus, the fact that Lively chose to file in federal court rather than to continue in the administrative process does not deprive her of the privilege. It is common with that plaintiffs with more serious discrimination claims would prefer to bypass the administrative procedures to seek a vindication of their civil rights. Lively's actions support rather than detract from the inference that the administrative complaint was filed as part of a genuine attempt to pursue Lively's claims. It was only by filing the administrative complaint that Lively was able to pursue the claims that she is pursuing. So I do feel that Lively filed on the day she did because she knew she had upfront notice that Wayfarer were about to litigate against the New York Times, and in order to get the bridge, to protect the bridge that Lyman keeps referring to between litigation and fair reporting privileges, Lively filed that at the time she did. I don't think she actually intended to file the lawsuit. So I think there's a lot of things, though, that, like I say, we don't have all the information. So there may be other stuff that may be appealable. I certainly think the timing of especially Alexandra Shapiro, who is, an esteemed appellate counsel, the fact that she was noticed in the court only 3 days after the New York Times filed their request for final judgment is telling. So we'll have to follow it and see what happens. We will know within 30 days what is going to happen. I don't want to say, oh yeah, they are going to definitely appeal, because, they even said themselves, oh, we're going to definitely, amend our, the claims that were dismissed without prejudice, and then they didn't. So we will have to see. But it's just some thoughts I had. I just kind of wanted to clear up some of the answer some of the questions with my own opinions, and maybe other people, who have different opinions. But these are just some of my thought processes. But I think they could go after the New York Times, or they may request a mandatory reconsideration. Not mandatory reconsideration, that's a process over here. They may file a motion for reconsideration based on new information. They may be considering different claims entirely against the New York Times. And we're saying the New York Times, they may do the same against Reynolds, against Sloan. We don't know. We'll have to keep an eye on it. But also, they may do nothing and just continue their fight on with Lively. So that's my thought process. We will know soon enough. Okay, have a good evening.